And hello once again. Welcome to the Employment Law Show. John Scholes and Lior Samfiru, again practicing safe distance at these COVID times, but the show must go on, so we're going to get right into it. You want to reach out anytime, by the way, whether it's during the show or afterwards. The phone number, 1-855-821-5900, help@employmentlawyer.ca. And for the next little while, Lior, I'm thinking covidrights.ca is going to be a pretty active website. You can go there anytime. There's lots of stuff, of course, about COVID-19 and the CERB and all those benefits and how you navigate that stuff. Coming up on the show today, Lior, we're going to get to employment law questions during COVID-19. That's all on the way. And some phone calls from our long-running radio show are on the way as well. But first of all, how are you doing, pal?
Well, I actually miss being in the studio with you and the rest of the crew there. And I'm hoping that before too long we can get back in our usual seats and do our usual thing. But for now, we're here. We're wanting to talk about employment law because guess what? Just because we're in this situation doesn't mean that employment law is not relevant. In fact, it couldn't be more relevant than it is right now because everyone's job has been impacted to an extent, whether you're working reduced hours or maybe your job has changed or maybe you're working from home or maybe you've been laid off or let go altogether. You need to know your rights. You need to know what you can do about it. And we want to talk about that on this show. We're going to try to cover as many topics as we can that are relevant in these particular times. But if we don't cover your topic or your specific situation, don't hesitate. It's not a big deal. Call, email. We're going to give you my contact information throughout the show. I want to talk to you. That's really all I've been doing right now between these shows. I've been emailing and speaking with people about their rights. Don't hesitate. There's no such thing as a bad question, always, especially now, though. So to start us off, John, on the week that was, I want to tell you about a matter that kind of made me shake my head, but I'm hoping it'll be resolved very quickly. So I spoke with this gentleman who worked for an essential business, a business that's still open, in their finance department. And he told me that all he does is he works on a computer, various spreadsheets, moves some numbers around. It's over my head, but that's really all he does. And he says that as long as he has a computer, he could do his job and do it 100% properly. Oh. So he wanted reasonably to work from home. He has a computer, he can connect, and that shouldn't be an issue. Well, his employer, for reasons unclear to me, said, no, we want you here. We want our entire team here in the office. So we don't want you to work from home, even though you're able to do the job at home. Well, obviously, this is not something that made him very happy because, leaving the house, going, taking public transportation to get to work, working in a room with other people puts him at risk. It certainly puts him more at risk than if he was simply working from home. And he talked to his employer and tried to convince them, and ultimately they said, no, not happening. That's when he reached out to me. So here's the interesting thing about it. John, if he, in fact, could not do his job from home, if he had to do the job only in the office, it would be reasonable for the employer to expect them to come in. You're expected to come into work if at all possible, if that's the way you have to do your job. But if there's a more safe, a more appropriate way for your employer to allow you to do your job where they don't put you at risk, they should use that approach. They should do that and help you protect yourself and your family. In this case, they could have allowed him to work from home, and they didn't. What does this mean? Well, if your employer puts you in danger unnecessarily, you could actually treat this situation as a constructive dismissal. You can actually tell your employer, no, I'm not doing this. And if they make you, you can treat that as a termination and require them to pay you severance. Now, I'm going to be connecting with this employer and trying to see if I can talk some sense into them. But if they don't back off, I'm going to treat this as a termination on behalf of this individual and get a severance. So I wanted to remind everyone out there, your employer does have an obligation to protect you. If they can and they don't, that could be a constructive dismissal. It's a very basic obligation that every employer has. They have to protect the safety, the health, the well-being of their employees, John.
And a reminder as well that employment rights are still up and running. Even in these times right now, you still have your same employment rights that you always would, right?
You absolutely do. The laws apply still, and we have new rights and new entitlements. The CERB, something brand new that we didn't have until a few weeks ago. And I've been talking to people all day and all week and all month about the CERB. If you have a question about whether you qualify, under what circumstances, how to apply, feel free to reach out to me anytime.
Yeah, COVIDrights.ca, as mentioned off the top, is a good way to do that. The phone call, 1-855-821-5900. And let's not forget pocketemploymentlawyer.ca. That's a wonderful resource as well. We do have a radio show. We do it across the country. I've been doing that for many years. You want to find a station near you and catch old shows, past shows, go to employmentlawyer.ca. We play them back here. First phone call for today is going to be right now.
I have a friend who works for a large chain for 9 years. Now, they've put all the managers on layoff, but they didn't really give a time like when they're going to hire them back. They said, oh, we'll promise that we'll get you guys back once layoffs are over. He knows that he can take a destructive dismissal and he can get severance. But what is the time frame where if he stays on the layoff that he's not going to get severance anymore? Is there like a time frame where he's given up the eligibility of getting a severance if he waits too long?
So, yeah, it's a great question, and the term, of course, is constructive dismissal. So here's how it works, and he's completely right, and everyone should be aware of this, that if you've been put on a temporary layoff, even now because of the COVID virus, even in this situation, in most cases, that is not something that's actually legal, or at least it gives you the right as an employee to treat that as a termination. You don't have to accept that temporary layoff. You can treat that as a termination, get your severance, and move on. Now, you don't have to do that, but here's what happens. If the company calls you back to work and you go back, then obviously you've given up the right to pursue that as severance. You're continuing to work. The other concern is that by allowing this temporary layoff to happen, by not treating it as a termination, you've now given the right to the company to do it again and again. Maybe it's a year from now, 5 years from now. If they do it at that point, you may not be able to say, wait, that's a constructive dismissal, because you let it happen now in 2020 with the COVID virus. So you can treat it as a termination now, get your severance. You can wait and see what happens if they call you back to work. If they don't call you back to work, at that point you can treat that as a termination. But keep in mind that by waiting, by allowing it to happen, you may actually be compromising your rights in the future. Now, this person said 9 years of service. Let's just, for fun, really see how much he's owed. Pocketemploymentlawyer.ca is the tool we go to find out how much severance anyone's owed. It's free, it's anonymous, easy to use. So let's plug information into pocketemploymentlawyer.ca. You see that on the screen right now. You see that someone in his situation after 9 years of service could be owed anywhere from 12, potentially as much as 14 months pay. So that's why it's so important to understand your rights. You can pursue that now or later. And of course, pocketemploymentlawyer.ca is your friend in that process.
Now that number there, just to make sure that the unique situation we're under with COVID rights and COVID-19 rather, that hasn't changed the metric when it comes to calculating the severance. That's the same model, correct?
So that's an interesting question. It hasn't changed, but if it does change, if the COVID rights virus changes the analysis in any way, it actually changes it to the benefit of the employee, in the sense that because it's going to take someone a longer time now to find another job, arguably they should be getting even more severance than the usual. So if there's a change with the COVID rights when it comes to severance, it's to mean that now you're owed more severance, not less.
Again, employmentlawyer.ca to find the radio show. Call number 2 from our radio show is coming up right now.
On Monday, the foreman actually told me that we have to reduce hours to Monday, Wednesday, and Fridays. And I just wanted to know if there's any way I can make them give me regular hours. I just can't afford to live off 3 days a week.
How long have you worked there?
9.5 years.
And how old are you?
54.
Yep.
So that's an interesting situation, because this person, if they're still working, depending on how much income he's earning, he may not qualify for the CERB. So he may be one of those people that is still working but earning too much to get the CERB, but not enough to live. Yeah. So here's the thing, John. A reduction in hours, in this case, from 5 to 3 days, is clearly also a constructive dismissal. Just like your employer doesn't have a right to lay you off temporarily, they don't have a right to cut your pay by 40% or whatever it is. That gives you the right to treat that as a termination. Our regular viewers know that that applies in the usual situation, and it also applies now in the virus environment that we find ourselves in. So he could accept it and continue working, or treat that as a termination. So my best advice here is talk to your employer and say, listen, I think this is a constructive dismissal. Let's not go down that route, and maybe they back off. Maybe, in fact, they increase his hours back to the way they were. If they don't, then he can treat that, if he wants to, as a constructive dismissal and get severance. And by the way, pocketemploymentlawyer.ca If you want to know if your matter is considered a constructive dismissal, you can go there as well. There's a tool there that allows you to answer some questions and find out if whatever the change that's been imposed by your employer, whether that in fact is a constructive dismissal. So again, pocketemploymentlawyer.ca.
Is there a general threshold as far as how much they can reduce your pay or how many hours they dock from you to trigger that constructive dismissal?
So generally speaking, we don't really start a constructive dismissal discussion until there's about a 10% pay cut. So anything below 10% usually would not be a constructive dismissal. We need something north of 10%. So if we're talking going from 5 days to 3 days, my math is not great, but maybe that's a 30% reduction. That is clearly not something they're allowed to do. So that is definitely constructive dismissal.
All right, we'll take a short break here. Coming up, questions during the COVID-19 pandemic, employment law questions, they are on the way, but stick around. 1-855-821-5900. Help at employmentlawyer.ca. That's a good way to email us as well. We'll be right back. Don't go anywhere.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back. Employment Law Show, reaching out to Lior anytime, 1-855-821-5900, help at employmentlawyer.ca. And for the next little while, you want to keep an eye on COVIDrights.ca. There's lots of information there, and that's what I want to get to, Lior, employment law questions during the COVID-19 pandemic. Some of these we already touched on in the first segment, but if you're just joining us, this is good stuff to go through once again. Number one, can my employer cut my pay or reduce my hours during the outbreak?
And the reason we want to talk about these things, John, is because there's, I've noticed this, almost an assumption that now, wait, there's a good reason. So the company's struggling, they're not picking on me, therefore maybe they have more rights and more ability to make changes than they otherwise would. Well, that's not the case. Even in the current situation, your employer cannot just decide, well, we're going to disregard the terms of your employment and do something else. So that applies to what you just said very clearly now, which is your employer cannot actually unilaterally change your hours of work, your days of work, or affect your compensation. If they do that, that's a breach of the terms of employment. If you're a 5-day-a-week guy or girl and that's your job, then they can't make you a 3-day-a-week person now. If they do, then you can accept that, and now you're working 3 days a week. Or you can treat that as a constructive dismissal. Now, I'm not advocating, I'm not sitting here saying, oh no, you must treat this as a constructive dismissal, not at all. I just want you to understand that that is one of the rights that you have. And always the concern in this situation is if you accept that reduction, you go from 5 days to 3 days, now you may have given them the right to do it again. And then maybe they don't increase you back to 5 days, or if they do, down the road they reduce you again, and then you're stuck with that. So I'm always weary about creating this precedent that could potentially compromise your legal rights. So no, when it comes to reduction in pay, in most cases, even now, that's absolutely a constructive dismissal.
We're talking about employment law rights during COVID-19. Can my employer put me on the old temporary layoff?
That's a big one, and there's been literally millions of people. That's unprecedented. So many people in such a short period of time to have been laid off temporarily. So despite how prevalent this is, you probably know 10 people just at the top of your head that have been laid off temporarily. Despite that, in most cases, that is not legal. Now, in a situation where the business has to shut down because they're not essential, the government said you have to shut down, the employees can't work from home. In those situations, if you're laid off, then it's probably okay. It's probably allowed because the business has no choice. They couldn't allow you to work even if they wanted to. That doesn't apply to most people. And most people, the company that they work for laid them off because there was the financial decision that they made. If that's why you've been laid off, even if it's a legitimate financial decision, that is still a constructive dismissal. That's not something you have to accept. My example that I always use is this. If I told someone that their pay is being reduced by 50%, they would instinctively know, wait a second, that can't be. That's got to be illegal. And of course, that's correct. Well, what is a temporary layoff? It's a 100% reduction in your compensation. So clearly, that's also not allowed. So no, even now, a temporary layoff in most situations, not something your employer is allowed to do, and gives the employee the right to treat that as a termination and get full severance.
Next question, if they permanently let me go, can they avoid paying severance?
Well, no, not at all. And in fact, a lot of people have been let go permanently, either right off the bat or they haven't been recalled back to work after a temporary layoff. That becomes a termination. And the company does not get a break because of the virus. The law is the law. So don't tell me whether it's right or wrong. I'm not even going to comment on that. I'm simply telling you the way it is. And the reality is that if your employer ends your employment, if you're no longer employed, even if it's COVID related, they have to pay you severance. We know that that's the case in the usual situations. It's the same now. So pocketemploymentlawyer.ca allows you to find out how much you're owed. It's based on your age, your position, and the length of your employment. And as I said earlier, not only do you get severance now, you could be owed more severance than usual because maybe in the usual situation you'd think, oh, I'll find a job in a couple of months. Now it could take you much longer than that because not as many companies are hiring. So that actually means more severance, John.
We're going through a bunch of questions here as it relates to employment law during COVID-19. Already, it's been shown you're seeing a lot of mental distress, a lot of anxiety. People off work, they're losing money, they're having trouble making ends meet, and this is going to continue long after the actual virus itself is under control. Can I go, or can an employee go on long-term disability for mental illness because of this?
John, I've spoken with dozens of people that have had no problem, no health issues before. Everything was fine. But given the stress that they're undergoing right now, this unique, very unique situation that they're feeling, anxiety, stress, fear, a lot of them have problems sleeping, eating, etc. And that now becomes a medical issue. If you're suffering from this anxiety or depression or what have you because of the current situation, that's understandable. And if you speak to your doctor, and you should speak to your doctor, and the doctor agrees that, yeah, this is something you're undergoing, then you can be off work, number one. You can be off work without any punishment. You can apply to the CERB, Canada Emergency Response Benefit, but also you may qualify under a disability plan that you have to work, a short-term or long-term disability. Obviously, it has to be legitimate and it has to be backed up by your doctor. But John, I don't know that I've ever spoken with so many people in such a short period of time that are telling me, my God, I'm so stressed, I can't do anything. Do I actually have to go to work? Well, speak to your doctor, and if your doctor agrees they shouldn't go to work, then you can be off work, apply for disability, and if you have any problems with your employer, with your disability insurer, reach out to me, we'll help you.
You know, another question we've been getting, as you can back me up on this during the radio show, is people are feeling now that because of the virus, their work is unsafe. Can their employer force them to work in an unsafe environment if they feel it is?
That's probably top 2 or 3 questions that I've been getting right now. I have a job, my employer wants me to come in, I am not feeling safe to do that. So here's the thing, John. You can't simply decide, I'm not going into work, that's too unsafe for me, so I'm staying at home. The problem with doing that is twofold. Number one, your employer may consider you to have resigned, and then you're out of a job. And also, if you're the one that decided not to go into work, you actually don't qualify for any financial assistance from the government. You don't qualify for the CERB. So you have no job and no income and no assistance from the government. Not a good situation. So what do you do if you're in fact feeling unsafe? Well, number one, talk to your talk to your employer first. See if you can come to terms with your employer on either changing your work environment or putting you on a layoff if that's what you want so you can be off work. Short of that, there's only 2 options. Number one, you can engage in a formal work refusal. If your work is dangerous, and that's the test, is it dangerous, then you can engage in a work refusal. That would require your employer to call in an inspector from the Ministry of Labor who will determine whether the work in fact is or is not dangerous. And if it is dangerous, they'll order your employer to make changes. If it's not dangerous, they'll tell you you have to go to work. The other thing, the last option, it could be potentially the simplest one, is if you speak to your doctor and your doctor says, you know what, given everything you told me, you should not be going to work. If that's how your doctor feels and he gives you a doctor's note, then yes, You can be off work legally as well as apply for the benefits that are provided by the government. But the message here is clear. Don't just simply decide on your own, I'm not going into work, that's unsafe. If you do that, you could have lost your job and not have any entitlements to benefits from the government.
You know, for the viewers that are still working, a lot of them, I guess, would be essential services. They're going to be feeling the stress. They're going to be feeling not well. Maybe productivity is starting to slip a little bit. You can't blame them, really. Can they be fired for cause by their employer if that happens?
Well, an employee that is going to work is still expected to do their job to the best of their ability. Remember, John, it's always difficult to terminate someone for cause. The fact that an employee may have done something wrong or maybe their performance is not exactly where it should be does not mean at all that they could be terminated for cause. It's a very high standard. It's the death penalty, right? It's reserved for the worst possible offenders. Now, I think that in the current situation, if anything, your employer has to be even more understanding and accepting, because it's not like if you're coming into work, that's it. There's nothing else on your mind. You're dealing with other concerns, family, your children, your parents. So is it expected that your performance may drop, and can your employer be understanding? Yeah, I think the answer is absolutely yes to both of these questions. You still should be doing your job, and an employer does have a right to discipline an employee that's clearly not doing what they're supposed to. But if your employer jumps the gun and tries to terminate you for cause before they should, in most cases, that's a wrongful dismissal, that's illegal, and you have to reach out.
Employment law questions during COVID-19. I'll throw one more of these at you, pal, till we move over to a phone call, and that is, can my employer or not pay me for overtime if I have to work it?
So overtime, the rules apply now as well. And again, this is a prime example when we say employment laws continue to apply even now. So if you work more than 44 hours a week, you get paid overtime, time and a half for anything over 44, whether you're a salaried employee or an hourly employee, you get paid. Now, in some situations, because a company lays off people, the people that are left may end up working longer hours to make up for that. So if you're one of these people, remember, you do get overtime if you work more than 44 hours a week, even if the company doesn't explicitly ask you to work it, but you have to work it in order to get the job done, you still get overtime. So anything over 44 hours a week, John, it's time and a half.
EmploymentLawyer.ca, that's the website to find the radio show near you. Listen to past episodes as well. We'll get to phone call number 3 right now.
Is there a time deadline for applying for severance from a company? I was let go from my company, and I got a ROE, and it said that, you know, there was a layoff due to lack of work. But in the meantime, what happened was I got cancer, and they said that they didn't have to give me anything. I was basically given about maybe 3 weeks' notice.
Wow.
Well, doesn't it kind of start looking a bit fishy if you're telling your employer that you have a serious medical condition, in this case cancer, and all of a sudden, well, now you're gone in 3 weeks' notice? Obviously, well, I shouldn't say obviously, but to me, it doesn't pass that smell test, right? It may be additional issues here. And if your employer lets you go because of a medical condition, that's illegal. That's a human rights violation. They can't hide behind some excuse if what they're really doing is trying to get you out of there because they don't want to have to deal with you and your medical condition. So that's a human rights violation. Now, in terms of how long do you have to pursue it, if you're going to pursue your termination entitlements, et cetera, that's a 2-year limitation period. You have 2 years from the date of termination to pursue those entitlements, and it's a strict deadline. It's not 2 years and a day or 2 years and an hour. It's 2 years exactly, and if you go over that, you've lost the ability to pursue it.
Still more to go here, but we want to take a quick break and get right back at it. To reach out, 1-855-821-5900, help at employmentlawyer.ca, and anytime you want to check this out as well, covidrights.ca as well. Employment Law Show continues. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back. Employment Law Show. John Scholes, Lior Samfiru, and the phone calls come from our radio show, employmentlawyer.ca. To find a show near you, listen to past episodes as well. We'll get to, what is this, phone call number 4 from the radio show right now, Lior.
I'm a 60-year-old employee with over 30 years of service. I work for a large municipal employer. I'm in a non-union position. And 6 months ago, I was given a letter telling me that my position was going to be terminated. During that time, they said there's going to be new positions being created, could apply for those jobs. Am I entitled to a severance even if I have not applied for any of the new positions? And number 2, I continue to ask my employer for information on my termination. They have not provided any information whatsoever. It was a couple of days away. Is it possible if my employer asked me to stay on beyond March 31st, and I have no issues with continuing work, but I don't want any of my continuing work to impact any of my future severance?
Great question, all of them, and a few things to unpack here. So first of all, let's talk about the idea that if you're being terminated and you're still working for the company, they give you notice of termination, it's up to the company to offer you another position if there's one available. You don't actually have to go out there and actively tell the company, I want to apply for this position or that position. If they have a job for you, if it's appropriate, then you can discuss that with them. So right off the bat, that's not something that this person has to worry about. Now, he thinks, well, maybe now because of the virus situation, even though I was supposed to be done shortly, maybe they'll ask me to stay on. Well, here's the thing. It's actually not a bad thing, because if he decides to stay on, and when they offer that to him, then the previous 6 months notice that they gave him, that notice of termination, evaporate. They're gone, which means when they do decide to terminate him, he's going to be owed full severance. Remember, if you get notice of termination, advance notice in writing of your termination date, that notice counts towards your severance. But in this case, if he continues working past that notice end date, then it's as if that notice didn't exist. And at some point when he is done, he's going to get his full severance. Now, full severance is the key word here. Let's plug his information into pocketemploymentlawyer.ca just so we see exactly how much he's owed. Now, we know that he's a 30-year employee, 60 years old, and he was given 6 months notice. Remember, that 6 months counts as entitlements. Well, John, he is a 24-month person. He's a 24-month guy after those 30 years. So at a minimum, the company's going to owe him another 18 months pay to get him to the 24 months. Or if they simply extend his employment and terminate him later, they'll have to pay him the full 24 months. That's why it's so important to know what you're owed, to go to pocketemploymentlawyer.ca to find out how much you're owed. You could find out you're owed 3, 4, 5 times what the company's offered you.
I want to slide in a quick question before we go from terminationquestions.com. This from Larry says, I was temporarily laid off due to COVID-19. My boss is asking me to continue doing work at home. He said it's the least I can do since I'll likely have a job to return to. What are my rights in this situation? Do I still have to work for him if I've been laid off?
Well, if you've been laid off, the company can't really have it both ways. If they're not going to pay you, you shouldn't be working. If they're going to pay you to work from home, then that's fine. So in a situation where the says we're not paying you, they can't decide, well, we still need you to do work for them. This is not slavery. That's illegal. You have to pay an employee when they work. So you should absolutely feel free to say no. If you want to pay me, by all means, I'm here, I'm available. Otherwise, if you're not paying me, I'm not working.
Final thoughts before we go, pal.
Employment laws apply still, and guess what? I'm not going anywhere still. I'm here available as well. If you have questions about your legal issues, terminations, severance, harassment, constructive dismissal, layoff, all that and more, by all means, or the CARB, call or email. I will answer your questions. I'll connect you with my team if need be. Please, there's always an answer to your questions, so don't hesitate.
All right, we're done. Carry on from there. To reach out, 1-855-821-5900, help@employmentlawyer.ca or simply employmentlawyer.ca. And for the next little while, covidrights.ca as well. We'll catch you next time. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.